All. A very warm welcome to a webinar cum workshop on intellectual property rights which is organized by RSRI. I will be the mentor for these sessions for next couple of days. So let me quickly introduce myself and then we can proceed for the session today. My name is Swapnil Sanap and I have done my bachelor's and master's in information technology. I am also pursuing my LLB and I am also a registered patent agent, which is a qualification given by the Government of India for spreading awareness and help and assist the individuals as well as corporates for securing their rights in terms of intellectual property rights. I have overall 9+ years of experience in this field and I'm having expertise in patent searching, patent drafting, patent prosecution, and all the associated mandates related to securing the intellectual property rights of an individual or any corporate. So let's move on to the sessions and specifically what all points would be covered in the next couple of days with regards to the intellectual property rights. Today's session, that is day one, we will be covering all the basics of intellectual property rights, mainly focusing on the basic requirements of IPR, how to identify different types of IPR, and mainly what are the different types of IPR. The session day two would be scheduled mainly focusing on the mandates related to patents and specifically covering all the requirements for filing a patent application in India. What are the relevant sections which would be required or to be taken care of while filing a patent application in India, as well as how and what are the various processes to file the patent application in India as well as abroad. Day three, it will be more focused toward the overall life cycle of the patent application in India and abroad. What are the structural differences? What are the formal requirements and other things? It will also cover the overall fees and forms required for filing a patent application in India. And it will also help you to analyze in terms of how a quality of a patent application is decided. Day 4 will be the most important day of session, which will actually covering the patent searching, types of patent searching, importance of patent searching, databases for conducting search and its methodologies. Day 5 will be the second important session wherein it will be actually covering all the basics of how a patent application is drafted, what are the requirements when we draft, or what are the basic requirements that needs to be taken care of while you actually draft a patent application in terms of specification and claims. Day 6, which will be the last day of the sessions, which will be actually more like a real-time example that we'll be discussing and some real-time scenarios in terms of how a patent application or a draft is to be written. So let's start with the today's session. So basically today's session, as I told you, it will be covering more on what IPR is, what is the requirement of IPR and the different types of IPR. So let's quickly see the specific contents of the session today. So we will be focusing more on the properties, what are the basic definition of properties, why and how the intellectual property came into existence, what is the requirement of intellectual property right, and then we'll be focusing on the different types of IPR in terms of copyright, trademark, industrial design, patents, trade secret, layout, design of integrated circuits, geographical indications, plant varieties, that is also referred to as farmers right, traditional knowledge, and then we'll be seeing generalized life cycle for each of these particular property rights. So let us quickly understand what is the actual meaning of property and different types of properties. So basically, intellectual property right is actually derived, as the name indicates, it is also a type of property. So let us understand in basic what is the meaning of property. Property is nothing but, let us in a very layman term, it is a thing which is owned or which is actually a ownership of a person or anybody. So these properties we are pretty much aware of, they are divided into two types: tangible property and intangible property. Tangible property are those property which you can actually touch, you can see, which you can feel. In contrast to this, the intangible properties are those properties which are actually invisible, or in rather different terms, which you cannot see, which you cannot touch, which you cannot feel. Tangible properties are further divided into two types. One is the movable tangible property and second is the immovable tangible property. The examples of movable tangible properties are, for example, chair, table, car, mobile phone. These are all the example of the tangible movable properties. Whereas the immovable tangible properties are those properties which you can see, which you can touch, which you can feel, but they cannot be moved from its location. What are the best examples? One is the house, one is the land. What else can be the example? An Electricity pole that is fixed in a land can be an immovable property too. In contrast to this, intangible property is divided into only one category. It is called as intellectual property. Intangible property means what I told you just now is that a property which cannot be seen, which cannot be touched, which cannot be felt. In very simple terms, this is a property which is invisible and which a person is aware when he creates himself, right? So this is what is called as intangible intellectual property or intellectual property in very simple terms. The examples of this are patents, trademark, copyright, geographical indications, and other etc. Today's session, we are going to touch base what these exactly intangible intellectual property are about. Let us go into a brief detail about it. Intellectual property and intellectual property rights. So as you may note that the only difference between these two terminologies is that a term right at the end is added. Whenever a right term is added at end of any particular subject matter, it gives a legal touch or a law-based touch to that particular subject matter. Best example, human rights. So rights associated with the human or the protection of a human being in the society are called as human rights. Animal rights. Animal rights are those rights which are actually given to the animals which protects their well-being in the society. Similarly, intellectual property rights is a right given to the intellectual property. Now, what is intellectual property? Let us divide this intellectual property into two parts. Intellectual property. So intellectual is a term which is always associated with a brain or certain creation of a brain or a mind. Whereas a property is, as I told you, it's the particular thing which one can claim right on or which can claim ownership on. Thus, intellectual property in combination mean that a person who can claim the ownership of any certain creation of a mind or a brain. This is actually a proper definition of intellectual property. Whereas intellectual property right is the right which I told you, it gives a legal base or a law-based touch to this particular subject matter. So intellectual property right is a legal right given by a particular government or a particular society for the intellectual property or any creation that has come to a human mind or human brain. I hope this is clear. This is a very basic definition of intellectual property. Let's move on to the further details of it. There are different types of intellectual property rights. Now, intellectual property right, for example, it can include patents, trademark, design, copyright, geographical indication, layouts of IC designs, IC circuit, and confidential information, also referred to as trade secret. Before going into details of each and everything, has anybody bothered to understand why there was a need of intellectual property right? So a very simple, let us start and try to understand a very simple scenario of the requirement of the intellectual property right. Let us assume a scenario wherein you have invested your, let us say, earnings, which is called as hard earned money, into something which actually helped you to buy a car. Let us say an Audi car. You just brought the Audi car and you were actually just taking it out of a showroom, and in next square a person come to your car and says, please get out of the car. This is not your car. This car belongs to me. How will you stop a person from taking away your car which you bought using your hard earned money? One way to stop such thing is by showing him the RC book. Other is by showing him the receipt of the payments that you made in the showroom. And third is by actually telling him that this car belongs to you or making certain calls to the showroom or to the person from whom you bought the car. Now just imagine the same scenario is applicable for all other tangible, that is movable as well as immovable things. Let us take an example of a house. Let us take an example of a land. If somebody wants to buy a land, the best way of buying a land is by registering it to a particular government or a particular authority, and then show that registration documents to a person who actually indicates or allegedly says that this land does not belong to you. So these are the documents which are evidential, or these are the proof that says that this particular property, that is a tangible property, belongs to you. Now let's take another in contrast example to this. Intangible thing, anything that has come to your mind, how a person can claim or say that this particular thing came to my mind first? It is impossible. It was rather impossible to prove that. There was no certain documentation, there was no certain proof by which a person can claim that this particular concept, idea, or any creation has come to my mind first. And thus, this was the requirement of an introduction of intellectual property right. And this was only the origin of the intellectual property right in any of the countries or across the globe. Now, most importantly, you need to appreciate is that intellectual property right is a field of law. So these all terms may be new to you, but I will try to explain it with all the real-time examples which will help you to understand it in a better manner. Now, why there was a requirement of different types of intellectual property right? Why there was a requirement of patents, trademark, industrial design, patents, copyright, etc. It can have a single uniform field called as IPR, and everything can be filed in this particular thing. No, the requirement was because the creation of the mind differs from person to person, or the creation in itself differs from thing to thing. Let us try to compare this thing with a real-time example. Let us assume that there is an engineering college. So whenever a person come to take an admission to an engineering college, there are always different fields of engineering. For example, there is IT, there is computer, there is electronics and telecommunication, there is an instrumentation, there is mechanical, there is any other field for as animation, for example. So these are all different fields or different branches of engineering. Can we assume why there was a requirement of these different branches? The best answer to this particular question is that every field has its own specialization. Every field has its own specific importance in that particular area of technology. Similarly, IPR as an engineering college, let us assume IPR as an engineering college, it has different fields or different branches because every branch has its own specialization. Why and how to identify which particular creation has to be distributed into which particular category or bucket, we are going to discuss in detail in today's session itself. Let us start with the first one. Let us start with the copyright. Copyright is basically a particular right given by the government to, let us say, any artistic, any literary, or any dramatic work. So in very simple term, what do you mean by literary work? Literary work is a work in basically it is a kind of anything associated with literature. Artistic work, anything associated with art, whereas dramatic work, anything associated with a drama. Let us take an example of a literary work. For example, a person writes a very nice poem on a paper. What is this? It is a literature, right? A person write a book. What is a book? Book is a literature. A person write an IEEE research paper. What is an IEEE research paper? It's a literature. A person write a thesis. A person writes a report. A person write a particular article. A person write a blog. A person write a software code. All these things are the example of a literary work. Whereas artistic work, what are the examples of artistic work? Anything that is associated with art. For example, a drawing, a color combination of anything that is put on a poster or a wall or on a paper. Any person who is sitting in a garden and he just draw a picture of a beautiful bird sitting on a branch of a tree. What is this? This is an art. So this art has come from a person's mind, and hence it can be a creation. It can be considered as a creation of that particular human being, and thus it is an artistic work. Dramatic work, in the other terms, it is all associated with the cinematography. For example, anything that is having audio, video, sound, text, animation, all these contribute to a kind of cinematography category, and this is again an art. So that is the reason why copyright came into existence, and these all type of, let us say, works, let us say literary, artistic, dramatic, all these types of work are categorized under copyright. Copyright, as the name indicates, a right which is given to prohibit any person from copying your work. So that's the reason copy and then right. The symbol that you see on the right hand side of this particular term copyright is basically a symbol which you may have seen on your daily basis in either in newspaper, in television, or even while watching some video on the YouTube. So these are all basically the signs which are actually given or authorized for copyright by the government. What right actually the government gives you for this particular type of work? Basically, it gives you a right to protect any person who is trying to copy or reproduce or adapt or to translate and then publish or then utilize or then sell this particular work which came to your mind first in the market and generate some revenue out of it. So this is the right given to a particular work which is filed under the copyright category. What is a term? That means what is the let us say what is the the validity of this particular right or the legal right that is given. Just for clarity, all the rights that we are referring today are all legal rights given by the government to a particular person against or towards the disclosure of his work. The term of copyright is the most maximum term that you get for any other type of IPR. It is generally till the life of author plus 60 years after the death of the author too. I hope you would appreciate what is the significant time right is given by the government to the copyright. What are the examples of copyright? Here we have categorized, I have tried to I have tried to categorize all these particular types of copyright, specific types of the copyright into multiple categories. For example, I just discussed literary work is one of the type of copyright. What can be covered under literary work? Some examples are novel, diaries, poems, etc. What are the examples of musical work? Musical work is also a type of category. Why? Because it is categorized under art. The jazz music, the improvisation music, all these are categorized under musical work. Choreographic work, dance, ballet, Zumba, and all those stuff are basically categorized under a type of choreographic work. Artistic work, painting, sculptures, etc. are covered under the artistic work. Architectural work, for example, buildings, the layout of the buildings, flats, houses, they are all categorized under architectural work. Figurative works are basically those works which are being, which are artistic in nature but has a specific intention or a specific function. For example, scientific, which the charts which are scientific in nature, the maps which you see on the Google Maps or on the the geographical book, these are all categorized under the figurative work. Cinematography work, movies, videos, etc. Photographic work, the photographs that you take, by the way, are also an example of the photographic work, because the way, the particular angle, etc. that are used by a person to take a photograph are his own creation, are his own skills required for it, and thus photographic work is also a category of a copyright. Program works, all the coders for softwares, all can be considered under copyright, especially for the computer programs that they write. The language of programs, for example, C, C++, C sharp, all these are considered, the code written using these languages are considered under the program work. Before going into the next session, next particular slide, I would like to quickly tell you a very interesting example. So for example, you all must have seen a movie, Three Idiots, and you must be aware that this Three Idiot movie is actually based on a book written by Mr. Chetan Bhagat. It's called as 3 Point Someone, or 5 Point Someone rather. Please pardon me if I'm wrong. It's 5 Point Someone. So you would be aware that Mr. Chetan Bhagat wrote this book and it was sold in the market and it gained a particular popularity, based on which the director of the movie Three Idiots decided to put it in a movie form. And thus, while the movie was made, the director forgot to take permission from Mr. Bhagat about usage of certain incidents or base their movie on this particular book of 5 Point Someone. What was the impact was that Mr. Chetan Bhagat, after the launch of the movie and after that movie gaining certain let us say revenue, after gaining certain popularity, Mr. Chetan Bhagat decided to sue this particular director of the movie. He was successfully able to do that and generate certain amount of profit out of it, as well as he was also given a certain recommendation, or let us say a kind of testimonial that this movie is basically derived from the book 5 Point Someone. Next type of intellectual property right is called as trademark. This name, actually, you may be aware, many of you may be aware of this term trademark, but let me try to give you a simplified definition for this particular trademark. Let us break this term trademark into two: a mark and a trade. So what does this indicate is like, firstly, you will understand that this is all associated with a trade. In other terms, it is all associated with a brand of a particular company, a trade of a particular company. So all these things are covered under the trademark. So the name, if we distribute or divide it into two, a mark which actually identifies or is associated with a trade is called as trademark. It is as simple as that. So what can be the mark? The mark can be anything. The mark can be a sign, it can be a logo, it can be a text, it can be a light, it can be a smell, it can be a sound, it can be anything. It can be a combination of these things. So anything, that is the reason the term mark represents thing. It can be anything which actually represents or identifies or associates your trade. Let us take a very simple example. Obviously, we are going to go into details of each and every example. But before we go, when I say McDonald's, automatically a particular burger is interpreted in my mind. Similarly, when I say Domino's, a pizza come in my mind. Why is this happening? When I was born, I was not told by my mom or my dad that Domino's means a company which manufactures a pizza. A McDonald means a company which sells the burger. How will, or it was not even taught in our syllabus, how does our mind associate this particular name with the particular product that are being sold? Similarly, when we say apple, there are only two things that come into your mind. One is the apple which we eat as a fruit, and the Apple, which is an electronic company which sells the costlier phones, right? Why this thing is happening? How your mind associates it? This is called as trademark. The impact of that particular name or the logo is that much on your mind that your mind automatically gets trained to identify a product which is associated to a particular company or a brand. Similarly, let's take a simpler example. When we say Balaji, there are only two things that come into your mind: Balaji temple and the Balaji chips. There is no other Balaji. We forget that Balaji can be somebody's name also. Balaji can be some company's or shop's name also, but we tend to forget that. We just correlate the Balaji to a particular reputed name of a company or something which is ancestrally known. For example, Balaji temple, right? This is basically a trademark and the impact of a trademark on a person's mind. What is the importance of a trademark? Now let us assume that today you come up with a very beautiful name, very mesmerizing name. Let us take an example, Google. Let us assume that Google was not in the existence today. Okay, something come to your mind, and this Google is basically a kind of a company which you have formed, and it sells all type of variety of utensils, for example. And within no time, the Google, your company, got popularity, and people from very corners of the world started buying the products from this particular shop. So what happened was, like, your competitor realized that this person is selling his product under this particular name, and maybe he can also sell it under the name, so that he can either hamper the business of this particular person whose brand it is, that is Google it is, or he may, let us say, sell the products by falsifying the name to the person. Obviously, when a customer buys a product, he will just rely on the fact that it is of which company. He may not be knowing that whether the company or the product being sold is authenticated or not. Obviously, people in India have started getting aware about such things, malpractices, but till date there are certain amount of percentage of crowd that is available in India as well as across the globe, who just rely on the fact that the company's name is there on the particular product. So what will happen is, like, when your competitor will start using this name, automatically your business would be impacted based on that. I hope I hope I'm trying to convey what you're understanding it. So basically, the importance of a trademark is that if your trademark is being used by anybody else, obviously your business is going to be hampered because of that. And thus, this trademark is a right given by the government to prohibit the name of your company, name of your product, name of your business, name of your services from being used by anybody at any point of time. And just for clarity, this trademark is the legal right given by the government. So you can stop anybody legally from using or exporting or importing the products under the name of that particular trademark matter. What is the validity of a trademark? The trademark is actually valid for 10 years from the filing of the application at the trademark registry, and then the government allows you to renew this particular trademark for next 3 years. That means the life actually next 3 times. That means total life of a trademark is actually 30 years. The bottom part of the slide shows the, the change in the sign or the symbol. So for example, when you file a particular application at a government office, it's referred to as trademark registry, you can start using the term TM, and you may be seeing in the market as well, there are a lot of products which are sold, and there is a small sign under this inside the circle which says TM either on the top or at the bottom. And once the government recognizes that it is a valid mark or it is a valid application, they will convert this TM into R. Basically, TM means the application and R means the registered mark. That means the government has allowed or given you a permission to use and to stop anybody else from using your particular mark. Let's take some examples, very famous examples. Hawkins, you must be using the pressure cooker at your home and you will be seeing this term Hawkins every time. Just imagine tomorrow any local vendor from your city start manufacturing a cooker and uses this particular name Hawkins. Won't the people in that city or this area, won't they be confused whether this Hawkins is actually the Hawkins cooker which was manufactured and sold in a reputed manner? His ad are also on the television, or anyways, under any circumstances, the Hawkins, original Hawkins, is going to be hampered in the business because of such thing. Thus, trademark, if the Hawkins have filed a trademark for their brand, they can easily and legally stop this particular local vendor from using their name on the products. These are all famous examples, and I do not have to even go into details of it because we use it in our daily life. Now just imagine on the right hand side, you see that Apple's sign. Apple name is not written anywhere at the top, bottom, or anywhere, but still our mind associates this particular logo with the Apple company. You know why this is happening? Like I told, this is completely the impression this company has created in our mind. Similarly, the bottommost image or logo that you see is, I don't even have to tell the name, but most of you may be aware this is about a Nike. So I have not written the name anywhere, but the symbol itself is sufficient to connect me to this particular reputed company or the products associated with it. At the initiation, I told you the mark can be of anything. I have just shown you two examples. For example, the word mark, the name Hawkins is a word, whereas the Apple is actually on the right hand side is a logo. There are other types. For example, let us take an example of a sound mark. So you all must have heard the Skype call tone. So you may be anywhere, but you hear this particular tone of a Skype, you automatically understand, ringtone rather, what I would like to say. If you hear this ringtone anywhere, you will be able to correlate that this ringtone is of a Skype company or a Skype call, right? So this is what that sound has created an impression on the mind of the customers, right? So this is what is the impression of this particular sound that has done. Another example is the color combination. I'm not sure if you have seen the logo of the company Wipro. Wipro is a very reputed IT company, and if you must have seen it a couple of years back, it was a yellow color sunflower. So the yellow color sunflower, wherever you see that sign on a maybe news or maybe in any building, you will be able to correlate it with the Wipro company. What happened is, like, in due course of time, now what they have done is, like, they have changed that color and converted it into a purple, a combination of purple, that is faint purple and dark purple. And now the people have started associating this flower, the updated flower, with the Wipro. This is what is actually a color combination mark, right? So different colors are used to identify what particular brand or what particular product a company must be selling, right? So sound mark, word mark, logo mark, then there is a color mark, and then there is a smell mark as well. The smell mark is nothing but basically a particular smell which helps us to associate this particular smell to a product. At the moment in the world, there is only one smell mark which is granted, and it is for a perfume called as Chanel. So Chanel is a perfume which we generally do not get in India, I believe, but this is only the company which has taken the trademark for the smell of that particular perfume. So just imagine, even a perfume cannot be stolen by, the smell of a perfume can even be stolen by any of the competitors. This is the impact of a trademark on the of the IPR. Industrial designs, also it is referred to as design patents. Now I hope you would appreciate that we are going step by step into details of each and every type of trademark. each and every type of intellectual property right, and going into the criticality and complexities of this particular intellectual property right. Industrial designs, as the name indicates, it is all associated with a design. But most importantly, it has to be a design of a product. So a design, if it is on a paper, that cannot be considered under the industrial design. What it could be categorized into, because it is on a paper, it is an art, and thus it will be by default categorized under copyright. Whereas industrial design is a type of IPR which is different from the copyright and dedicatedly allocated only for the design of the products. Products means tangible things. Tangible things can be what? A toothbrush, a mobile phone, a two-wheeler vehicle, a car, a laptop, a mobile phone, right? Anything that you can touch, you can see, you can feel is categorized under the tangible thing, but a design of that particular product can be considered under the industrial design. If you come up with a specific design of a product which is very unique in nature and it helps a person to differentiate between the products, then such design can be categorized under industrial design. And that is the reason the definition of this particular industrial design says that any ornamental or aesthetic aspect of an article, right, which is associated with a product is categorized under industrial design. Most importantly, while identifying whether it's a design or not, person should not touch or use that particular product to say that this is a different design. He should be able to differentiate that particular product or the design of the product with his naked eyes, with his open eyes, right? What is the validity of this design patent? The design patent actually is valid only for 15 years as per the law. So after 15 years, what happens is like people are allowed to use such design in the market without, and they don't have to take permission on the original owner, or the original owner cannot stop these people from using this particular product in the market. I have tried to show two different, completely different examples of industrial design so it will be more clearer for you. On the right hand side, you see that there are three different bottles which are kept. Now these three bottles are different to say that I do not have to actually touch and use this particular bottle. I can just see it using my eyes and I can tell that these three bottles are different. I have just pasted this particular, the name of the companies there just to clearly identify that these designs belong to different companies. For example, Bisleri in the center of the image is different, completely different from Aquafina and Kinley bottle. Do I have to elaborate actually on this part? It is very simple to understand. The shape or the aesthetic appearance of these bottles are completely different, and hence each company has taken rights on the design of these particular bottles. Thus, Bisleri cannot use the bottle shape of Aquafina or Kinley. Similarly, Kinley or Aquafina cannot use the shape of the water bottle of Bisleri. The example on the left hand side is about a coat which is generally used in foreign countries, especially when there is snow outside. So what this lady has come up with a design is basically a jacket or a coat which is having two parts. One is on the top part you see it's a normal coat, whereas the bottom part if you'll see it's of different color, and this is actually a removable kind of material that has been pasted. For example, it is a plastic. Whenever a person walks in rainy season, generally his the ankle and the back foot actually tends to spread some water on the back of his particular clothes what he's wearing. Thus this particular arrangement of this particular coat helps to avoid the clothes getting dirty, right? So whenever it's rainy, you can just fix this particular bottom part of this particular clothes and then go out and easily come back. Whenever it's not raining, you can just remove it using that particular arrangement there. I hope it is pretty much clear. When we talk about industrial designs, also referred to as design patents, they are all associated with the aesthetic shape of a particular product, right? Layouts and topography of industrial integrated circuit. Now this is a bit complex. Basically, you all must have seen in terms of hardware or electronics, there is a basically black stone-like structure which is available in any electronic machine. For example, let us assume you open a particular electronic device, for example, a computer or a laptop, and then you see that So there is a circuitry, there is a green color circuitry or a plate inserted in this particular machine, and there are some black dots which are available on that particular machine. Basically, if you dismantle or remove it particularly, this is basically a kind of chip, or we call it as IC, that is installed on this particular board. Now the protection, why it is important, because every chip which is installed in this particular board has its own functionality. The people from engineering background or people from technical background would appreciate that when I say individual function, that means it's referred to as a dedicated function. For example, let's take a simple example. When I actually want to unlock my mobile phone, I have to either touch my finger to this particular sensor, or I have to press that particular unlock button which is provided on the outside boundary panel of this particular phone. How will a phone or a machine understand that upon pressing that button, or that putting the finger on the sensor, how do I have to unlock it? So this is all fed into this machine in this small chip called as IC. So this particular type of IPR or a field of IPR helps you to protect the shape of that particular IC, as well as the electronic circuitry or the electronic layout or design of that particular circuitry. The term design here is also used because this is all associated with the IC. Let us not get confused with the design term used here and in the industrial design. Industrial design is always associated with a product and a whole product, not a part of the product. Whereas this layout or topography of integrated circuit is always associated with the IC. So any IC or any topography thereof is protected under this particular thing. In India, the layouts and designs of ICs are protected under Semiconductor Integrated Circuits Layout Design Registry. This is the office, this is the government office which are actually working dedicatedly for securing the rights on the layouts and design. This is what I was referring to. On the top, you can see this is a small chip which is actually insertable on the board, which is shown on the bottom part of this PPT. This board, the green color board, is referred to as a PCB, printed circuit board, whereas the black color part with the teeth is referred to as IC, or integrated circuit IC chip. So this chip, whenever it is installed in this particular board, it actually helps to perform a dedicated function, right? I hope this is clear to you. Let us take a small pause here.